The consultation and legislation process has taken a year and 9 months to get to this stage. But the final product is now here and is accompanied with a website which gives claimants everything they need to know about the process and a new training course at the University of Gibraltar for chairpersons.
The feedback from the Bar Council and from the different officials that have read the guidance notes is that it is simple enough for a person who, because they feel that the case is extremely strong and do not need solicitors, or because they can't afford one because they've just been dismissed, to be able to go on the website and obtain guidance from the website.
The core value embedded in the reforms is fairness. All fees for litigants are abolished and the maximum award for a successful claim is no longer capped. But a set of guidelines has been issued for compensation. There are also guidelines for costs in the event of an unsuccessful claim in order to ward off spurious claims, and parties are obliged to attend mediation without lawyers before a case even goes to a tribunal.
The rules are designed to achieve fairness on both sides. The employee should know that they should only proceed with a case which they expect to win, because if they lose, the chairperson can, in his or her discretion, award the costs of the employer. Similarly, employers should know that if they defend a case of unfair dismissal, which was clearly one of unfair dismissal, the chairperson may also, in his or her discretion, award costs. In order to try to stop cases even from reaching the employment tribunal process, we've introduced compulsory mediation. The compulsory mediation does not require any party to pay fees, and I think in an important innovation, the parties, when they meet with the mediator, who of course would be a qualified person, will do so without legal representation.
Chairpersons are now appointed independently by the Judicial Service Commission, and the roster is kept by the Commission's secretary, so they are appointed to cases randomly.
The amendments to the Employment Act guarantee that whereas the Minister for Employment continues to appoint the chairpersons, the Minister only makes what is essentially a formal appointment, because the Minister can only appoint a chairperson on the advice of the Judicial Services Commission. So I cannot appoint anyone unless the JSC tells me that they're suitable, qualified, experienced, and so on. And to ensure absolutely impartiality and objectivity, once the JSC advises me who the chairpersons are and I gazette them, it will be the secretary of the tribunal who will literally pick the chairperson off a list, so that a case comes in, the secretary appoints the chairperson on the list, and if that person has a conflict or a calendar conflict, then the secretary will go to the next person. So it truly is completely divorced from the political process.
The Ministry has completed this reform following a lengthy consultation process with the Bar Council, the Chamber, the GFSB and the unions, as well as advice from the Chief Justice. This is a new legal architecture, so the Minister says it will be reviewed in the coming months to make sure it's working well for everyone.